we'll go back on the record. We are back on the record and we can call the case for Casey Goolsby. It's 26 CR 313. Mr. Goolsby's present in custody, scheduled for, looks like a bond hearing this afternoon.
Correct.
Okay, Mr. Griffin.
Your Honor, this case has been set for a bond hearing a little bit down the road because Mr. Goolsby did have a parole hold. He has since been lifted. But $25,000 bond is way too much for him to be able to possibly afford in this case. So he's asking for a reduction to $3,000 to $5,000. His co-defendant her bond was at $25,000. It was reduced to, I believe, $7,000. I know we're asking for a little bit less than that. The primary reason is his co-defendant is 100% disabled. She was in a serious car accident a number of years ago and has essentially been literally physically disabled ever since then, unable to work, in many ways unable to take care of herself. And Mr. Goolsby is that resource for her. She's been out, she's on the street right now, and is very much struggling. So we are asking for a reduction, one, for him to be able to get out and assist her. Second, there is a home where Mr. Goolsby has available to reside permanently. It's 611 Aldea Point with an individual by the name of Christopher Atencio. So, and he would be able to bring her along there as well, which would make a huge difference in her life. Mr. Goolsby has been a chef in the area for 25 plus years and doesn't have work lined up right now, but given his experience, knowledge in the field, he knows very much that he would be able to get work very rapidly. And so he has stability, he's got work, and a fairly serious obligation for someone who really needs his assistance. So we would be asking for a bond reduction to that level.
All right, thank you, Mr. Griffin. People's position?
Judge, the people would be asking for bond to remain set as is at $25,000. That is the scheduled bond amount for the charges which the defendant is charged with, which is an assault in the first degree and F3 with 2 crime of violence enhancers, both for serious bodily injury and use of a deadly weapon. The sentencing range on that the defendant is facing is a mandatory minimum of 10 years in the Department of Corrections. And if found to be a habitual criminal based on his criminal history, which I'll get into in a bit more detail in a minute, would be 64 years of mandatory DOC time. The allegations in this case are equally gruesome as the charges make them sound like. I know this court did not preside over the preliminary hearing. However, the 2 exhibits admitted by the people in that hearing are in the case file for the court's review. And the court can see the injuries in there are quite extensive. Several serious lacerations to the victim's head, requiring many staples, including a broken nose as well. And those caused by the defendant and co-defendant beating this victim repeatedly over the head with metal pipes. As I spoke before, the defendant does have a serious criminal history, counting 6 prior felony convictions, including 2 escape charges. So the people are concerned about his willingness to show up for court with those charges, as well as 5 failure to appears in his history. The people have significant concerns about the defendant's willingness to follow his court orders, show up to court. People are concerned about community safety, and all of that, along with the charges and the allegations involved in this case, warrant a $25,000 bond.
Thank you.
If I could just briefly on the criminal history.
You may.
Mr. Goolsby's priors are 3 of them are drug related, DF3s and DF4s. The escapes are from a time when walking away from ComCorp was an escape. And so those are the nature of the convictions that he has. He doesn't have anything of any violence, doesn't have anything involving like physical victims, and no weapons charges or anything like that. So I think that's a relevant factor. I mean, just the number of convictions is one thing, but the nature of the convictions is important as well.
Thank you. All right, the court has considered the arguments of counsel. The court has considered the contents of the affidavit for arrest warrant that was filed when the case opened back in January 2026. I have also now reviewed exhibits 1 and 2 that were filed here in May in conjunction with the preliminary hearing that was held in this case. I have considered the 4th Judicial District bond schedule, which provides me with a recommended bond based solely on the nature and level of offense an individual is facing. And from there, the court is to consider factors that are outlined pursuant to statute, factors that ensure that an individual will appear in court as ordered, that ensure and suggest stability within the community, and things of that nature. So I have considered the arguments that have been made in this case. The recommended bond amount for this type of charge is $25,000, and that is the bond that is currently set in this case. Due to the nature of the injuries that were suffered in this case, even considering the co-defendant's situation and the bond that was lowered for the co-defendant, I do have community safety concerns that are not sufficiently alleviated just by the identification of a place where Mr. Goolsby can live and the suggestion that he could find work based on a lengthy work history. So at this point, I just don't think those concerns are alleviated by that additional information that's been provided, such that it's appropriate to reduce the bond so substantially. At this point, I'll deny the bond reduction and maintain the $25,000 cash surety or property bond. I do find that that's appropriate given the nature of the case, the severe injuries that were suffered, and the criminal history, even though I understand the escapes are not of what we would normally think of as an escape. They were under the previous escape statutes. I know that we also have a trial date set that is coming up very quickly, although there was a motion to continue the trial filed by the people. So let's maybe see. I also know that we have a pretrial readiness conference set next week, but I guess we're here. I don't know whether we should just keep the date next week or discuss the case this week.
I think if we could, I wanted to talk to Mr. Myers about the continuance request. So maybe just leaving it on for next week would be best way to go.
That's fine with me, Judge. It's a VRA case, so it would have to be left on for next week, whether or not we discussed it today anyway.
Okay, we can maintain next week's date and address the status of the case at that point.
Okay.
So let's maintain, we've got pretrial readiness conference next week, Mr. Goolsby, June 22nd at 1:30. Council will discuss kind of the status of the case and we'll check in on it when you come back next week. Is there anything else we need to address today?
I don't believe so.
Okay, all right, thank you.
Yes, Judge, can I call Ms. Hayden on the WebEx? I believe it should be set.
Yes, we can. This is 24 CR 2342. Ms. Hayden is present on a summons appearing for a hearing on probation this afternoon.
Yes, Judge. And I believe probation is here. Our request would be to trail the Mesa County case. It does look like that is the only new allegation, or the only allegation, excuse me, in the complaint report is that new case. It's 26M1023. Looks like it is currently set for a status conference on the 15th, so next month, at 8 a.m. I have been in contact with the Grand Junction Public Defender's Office because our office was appointed on the record without any application here. They couldn't just open a file there, so I believe someone from that office is reaching out to Miss Hayden to get an application and working on getting her assigned an attorney out there.
All right, does probation wish to add anything?
Good afternoon, Your Honor. Margarita Castagna with probation. No additional information at this time.
Okay, and any objection from the people to proceeding and trailing the new law violation, which is the only alleged violation of probation?
No, Your Honor. I know the probation officer has some serious concerns about Ms. Hayden and kind of the state of her mental health and the direction that she's going. But I think it makes sense to trail the Mesa County case at this point.
What day did we do?
All right, and Ms. Hayden is raising her hand. Ms. Sullivan, do you want me to?
Sure, I think it might be Miss Bristol, who's her caseworker.
Okay,
Yeah.
My name is Ryan Parmenter, and I'm the residential supervisor for where Miss Hayden currently resides. We just had a question about if she takes any type of plea deal or get these charges, what does that look like for her probation?
Right. I will call Miss Hayden and talk to her about that again at a later date. That's not for right now.
Okay.
yeah, I think council's going to be in the best position to provide that information. I also do have Ms. Bristol raising her hand.
We were just asked by the prosecuting attorney before we did the arraignment, while we were doing the arraignment, if what would happen so that they can decide and figure out what they need to do as next steps here in Mesa County. We have another hearing in July for that arraignment.
Yes, that's in a different county. I've spoken with Miss Hayden about this. And we're working on getting her an attorney out of Grand Junction.
Okay. So what do we tell the prosecutor, the deputy prosecutor, when we go in July?
That she needs an attorney.
I think the hope is that an attorney will be identified and assigned to the case in Mesa County before you go back July 15th. And it may be helpful if you all can help Ms. Hayden contact the public defender's office out in Mesa County to figure out what, if anything, they need from Ms. Hayden to consider her application for court-appointed counsel. But once an attorney is assigned out in Mesa County, then Ms. Hayden can meet with her attorney in Mesa County, and they can have conversations about what, if any, offer has been made in that case, what the prosecutor's wanting to do in that case, and what makes the most sense. And of course, then they'll want to all loop in Ms. Sullivan as to what's going on with the probation matter here, because whatever happens in that Mesa County case could impact Ms. Hayden's probation here. So ultimately, I think the goal here is to get Ms. Hayden an attorney in the Mesa County case that will be able to help inform Ms. Hayden of the best way to proceed. So we can set another hearing here on July 20th at, let's see, we could do that at 10 o'clock. Perfect. So Ms. Hayden, we'll see you back here, Division 14 in El Paso County, July 20th at 10 o'clock. Your summons continues to that date and time.
And is it okay if Ms. Hayden appears virtually for that court date?
Any objections?
Your Honor, I have another hearing in a different division at that time.
Okay, and we can wait to call this matter until you're free and able to come on over. So any objection from the people to a virtual appearance for Ms. Hayden?
No, Your Honor, and that's a review.
Yeah, we'll set it for a review or just call it a hearing on probation, but it won't be a probation revocation hearing. So that's why we'll set it in the morning, just to kind of keep it on everybody's radar that it's not set for an evidentiary hearing. Is that right, Ms. Sullivan?
Yes, Judge, thank
Okay,
you.
all right. Then Ms. Hayden, we'll see you back July 20th at 10.
Thank you.
All right, thank you.
Judge, if I could also call Sean Moless.
We can. This is 21 CR 2642. Mr. Moless is present on bond. This case is scheduled for review today.
There's a lot of errors and stuff on the computer I'm kind of worried about because
Hey, let's hang tight for just a minute, Mr. Moless. Okay, let me hear what Ms. Sullivan has to say, and then if we need to discuss some errors, we can have that conversation, okay?
Yes, Judge, thank you. We would be asking for an additional opportunity to complete restoration out of custody today. That would be our request. Mr. Moless does have some concerns related to the social security number that is linked to this case. I've explained to him that we are at a point where we are working on restoration, and that can be addressed at a later time. But he is very concerned about that.
yeah, because it was an old bait line that they used against the case in here, and it's used doesn't have the clearance level and stuff like that. That the case that they gave me, the social security number at 7301, they gave me actually has the blocks on it, and so it has a lot of information, detailed information in there about this case, about a bunch of other cases. And a lot of cops spent their time putting it on that social security number. And it is just, I'm supposed to use that one. I don't have no legal ties or nothing to this one with 7309, because that one is used as an old, it's a broken line. It's a broken social security number. And I just don't want them to at all have any problems with social security numbers.
I understand your concerns, and
Yeah.
I appreciate that. I don't know much about this issue, but your attorney and the district attorney can try to work through and see if there's a change that needs to be made in the paperwork regarding.
Just so it lines up, right? Because I don't want, if there's something on there that helps me out and you guys are able to see it, you won't be able to see it if it doesn't have the social security number on it.
Okay.
But it has something that says I already completed a lot of these classes and everything. So it said I've already done a lot of this stuff.
Okay.
And on that number, yeah, it has a lot of the detailed stuff on there too.
Yeah, and I don't know much about that.
Yeah.
What I was wondering, though, in my review and preparation for today's docket is whether potentially doing check-ins down in the competency docket might be helpful.
I'm not sure that would be helpful, Judge. I'm not sure that would be
This case
helpful
is,
at this
we
point.
scripted it. It was really a fabricated case. It never really happened.
Well, and so Mr. Mollis, hold on for just one moment,
Yeah.
because the thing I need you to know is anything you say here in the courtroom is
Yeah.
being
Well,
recorded
that's fine.
and
We
could be
did a
used
data study
against you.
during COVID. In COVID, we did data study, and it was called Peppernickel. It was supposed to be a part of a clue scroll, and we did it to see where it goes and where it ends at in the case. We refabricated it after O.J. Simpson case. It was a fake case. We scripted it,
Okay,
and it was completely rehearsed. It wasn't supposed to even stay on there. It was supposed to travel with somebody else, but it didn't work.
okay,
And the people ended up leaving it in the computer system. They never took it out. The data group didn't do it. So they didn't take
Okay.
it out. So that was why I was kind of worried about a case me pleading guilty. If it is legal, I don't want to plead guilty to a case I didn't do.
understood. So right now, where we're at, Mr. Mollis, is you've been ordered to do this outpatient restoration, these classes. And so far, or your most recent referral at least, was to Gateway to Success, to be doing your classes there. They have stopped those classes at this point because they haven't seen you enough. Okay.
Yeah.
But we do need you to go to those classes. I think we probably need to re-enter an outpatient restoration order for Mr. Mollis so that a re-referral can be made. And that would either be made to Gateway or to Diversis, generally. And Mr. Mollis, you need to be going to these classes. That's part of.
I have a thing that I guess like I've already completed them. I got awarded a certificate and all that from them. That was like
We don't have that. So that might have been something else.
Yeah.
There might have been some other classes you were ordered to do, but right now you're ordered to do this outpatient restoration, which is generally either once or twice a week. It's very consistent. They set you at the same day and a day of the week and same time every week so that you can plan around it if you work or have other things going on, so that you can go to these classes consistently. But we need you to be going to these classes And then as you're receiving that treatment outpatient, you'll do updated evaluations that will tell us the best way to proceed.
Okay, yeah, because that's what I did it. Okay.
That's okay. So, but we do need you to get started with it again. So that's why I said, unfortunately, it's going to take a few weeks because what happens is that referral gets made. It usually takes a week or two for a agency to be assigned, and then it takes them probably a week or so to reach out to you and you guys to get into contact, and then for classes to be scheduled. Right now, we have a 91-day review set with you on July 20th at 8:30. I suspect we're not going to have an evaluation by that date.
Okay.
But ultimately, what I want to see when you come back on July 20th is that you are back in those outpatient restoration classes and attending them regularly, okay? Because that's one of the benefits of being able to be out of custody during this process, is that you're actually going to the classes, okay?
I'll go to them. I'll go to them if I have them. I just don't like to keep repeating it over, you know?
And I understand, but we have to keep doing that until an evaluator comes back and says, okay, now your case is ready to move forward. And until that happens, you have to stay in those classes, okay? People's position.
Judge, I mean, my only concern, which the court has sort of addressed already, is just the repeated failure to engage with those services.
I had it. I didn't know I was, had it. It was,
If the court is wanting to issue a new outpatient order and go that direction, that's fine.
Okay. I do think, so what we will do, Mr. Mullins, and I'll try to outline this the best I possibly can for you, okay? We'll enter a new outpatient restoration order, and I want to see, again, when you come back on July 20th, that you have gotten yourself back into that outpatient restoration and you're attending regularly, all right?
July 20th. Okay.
Do we have bridges on this case? Yes, we do. It looks like. Okay. What I was going to say is, Mr. Mullis, I still think you could maybe benefit from the competency docket in the sense that we could have you coming to court more frequently to provide you services, to provide you support.
Services after this. I just want to just go on business again.
And
It's taken
that's,
me a long time getting out the record, and I'm not supposed to be connected to the name that I'm on now.
well, and that's fine, Mr. Mullis, but then what I need you to do is follow through with these classes
that's
and
what
get
we
back
do.
into them,
Yeah.
okay?
All right.
Because if it keeps kind of going this way where you attend a few classes and then they tell me that you're not engaged and then they discard
that
you
one.
and things like that. But if that happens, then I may need to have you reporting to court every week.
Yeah, I used to do
So that we can be sure that you're.
courtroom stuff. Yeah.
Yeah, so that's why, because again, if we can't have you doing these things out of custody, oftentimes people will do them in custody, okay? And right now, you're out of custody. I would like to be able to manage this with you out of custody,
Yeah.
okay? So that's why, but I just need you to follow through and make sure you're going to the classes consistently, okay?
Okay.
Does that make sense?
And Judge, is it possible to do a referral to Diversus specifically? I do believe that Mr. Mullis has previous experience with Gateway to Success that was not necessarily the most positive from conversations with his mom. And so if probably be better.
We don't have to do Diversus. It's just add more problems to it. I'll do the original one. I mean, I don't care. It's not going to help me anymore. It's just going to make more stuff worse.
Okay.
But
Well, we can just make a general referral and they'll send you to whoever is available to provide the services. And it may be Gateway or it may be Diversus. But just get back into those classes. Mr. Mullis, we will have you back on July 20th at 8:30.
Okay.
Okay. And your bond continues to that date and time. And we'll check the status of outpatient restoration then.
Thank you, Judge.
Thank you.
All right. Thank you, sir.
People of the State of Colorado versus Melvin Henderson. Mr. Henderson is here on his cases 26 CR 396 and 26 CR 394. Good morning.
John the count for the people.
What is the status for Mr. Henderson today?
Your Honor, we have a proposed disposition. Paperwork has been uploaded already on the United States case.
Perfect.
On the 9/4 case.
I do have that. Is it your request that I start with the 9-4 case? All right. Mr. Henderson, I'm going to go through this paperwork with you and make sure you don't have any questions, okay? This does state that you've agreed to plead guilty to count 2. That's a class 1 misdemeanor for theft. The people have agreed to dismiss count 1. There's a stipulation that sentencing will be open to the court, and you do have 119 days of credit to be applied to whatever sentence you receive. There is also an understanding that restitution will be reserved for 126 days, but the people will make sure that you are aware through counsel of the amount of restitution within 63 days. Does that make sense? Okay. And again, I have signatures from you and your attorney back on June 11th. I do have the people's motion to add count 2, the theft for the purposes of the plea. I also have the motion to dismiss count 1. And I have the advisement of the elements for theft. It looks like you went through this document and you reviewed both the elements that are applicable to theft, such as thing of value, possession. You also reviewed the events that took place on February 10th of 2026. And again, you signed off along with your counsel stating you understood this information. Do you feel like you understood what you're pleading guilty to today? You also went through the Rule 11 advisement form. I see you've provided your highest level of education, your age. I see your initials going down the sides of the page and your signature at the end of the document as well. This form goes through all of your rights to go forward with trial. If you would like, we could set your case for trial. You'd be represented by competent counsel. You would be able to testify or decline to testify. And if you were convicted at trial, you would have the opportunity to appeal. But again, you signed off stating you do not wish to go forward with trial. Today, you want me to accept your plea. Is that correct? Is anyone forcing you to do this today? Are you satisfied with the advice of counsel? Are you under the influence of anything today affecting your ability to fully understand our conversation? Have you ever served in the military? Counsel, is there anything else you would like me to advise your client of? Okay. To count 2, theft, a class 1 misdemeanor, guilty or not guilty? I will accept your guilty plea as freely made, voluntarily made, and knowingly made. As it relates to sentencing, immediate sentencing for the people.
Governor, we are asking for 364 days jail. At this point, we believe that containment is appropriate. Mr. Henderson has a lengthy theft history that includes 25 felonies, mostly theft, other charges such as 2 burglaries, and then 22 misdemeanors, which are also mostly theft. There's an ongoing pattern. Mr. Henderson has demonstrated that he's not going to stop. So we are requesting the maximum jail sentence. Thank you.
Thank you. Does he still have a parole hold?
The hold is still in place as of this morning, Your Honor. So I do want to address that as part of my sentencing.
Okay, go ahead.
I am asking the court to impose a sentence of time served of 119 days at this point, in part because of the situation in Minnesota. But I want to start by responding regarding Mr. Henderson's criminal record. I think it's always a dangerous game to be comparing criminal records across states because of just how different, first of all, the general culture of it was. I know that when I came here from Florida, a place where it is we need for people to get a felony conviction every time they're charged with a felony, it was far more shocking than now that a judge is saying this is a felony conviction with a lot more weight than in other jurisdictions. I think some of that is at play. I also know that Minnesota, I've tried to research this and understand it, but not being involved in Minnesota, I'm still working with it. So Minnesota has a system of aggregating misdemeanors into gross misdemeanors, which get reported as felonies because we don't have a version of a gross misdemeanor. All of which is to say, we certainly agree that Mr. Henderson has been on a rough streak lately. I don't think it is quite as stark as people make it out. That having been said, Mr. Henderson is aware that he's been struggling a lot, and this has to do with his mental health and with his substance abuse issues, and he's trying to address those. He has both been working very hard while he's been in custody to take advantage of those things that are available to him while he's in custody for treatment, and also making plans for while he's on the outside. If I could approach next and the sentencing documents, which I did upload, but I think are still pending.
Thank you.
Showing these to the people, Your Honor, the top page here is a letter from Hope Homes showing that Mr. Henderson has been accepted to their program. It would be his intention to reside there if he is able to. The rest are certificates of coursework that Mr. Henderson has completed while he has been in custody. So Mr. Henderson has not been idle. He has been working to address substance abuse, his mental health, to earn certificates for avenues of employment, to try and find himself some gainful employment when he is released. He's very focused on trying to change the street that he is from.
If I could just interrupt, I need to step out. If Mr. Terrell could cover, I have a 9 o'clock virtual. Thank you.
That's okay.
With respect to the parole, so Your Honor, I have confirmed that Mr. Henderson's parole expired on June 30th. So just this past weekend, that was part of the reason we asked to set up here, because it is our hope that Mr. Henderson can be released directly from here, that Minnesota will ultimately choose not to extradite him.
Okay.
He has already been served with the governor's warrant on that. He needs to waive extradition on that parole hold. So he's aware that he may be brought back to Minnesota, but we are hopeful that once he has fully completed that term, they will ultimately choose not to do that. We really won't know that until he is released by this court, be it at the end of 364 days, or for a term of probation, or for a term of time served, because he has been already served with that governor's warrant. Minnesota has not been good for Mr. Henderson. It was one of the first things he said to me when we sat down was, is there a way for me to avoid going back to Minnesota? Not because I don't want to serve my time, I'll serve it all here, but I know that Minnesota was very bad for my mental health. I was not in a good place, didn't have a support network there, and I want to try and rebuild myself in Colorado. And if there's any way for me to get released directly here in Colorado, that's what I want to do.
Did you say he was from Minnesota?
Actually from St. Louis, Missouri.
Okay, gotcha. Just wondering.
So, Your Honor, that is what Mr. Henderson is endeavoring to do. Don't quite know what will happen yet with the parole, but we are optimistic. And I did confirm with this parole officer that June 13th was the date that would expire. He was also not able to, or he was not able to advise me what would happen if he was kept in custody there, whether he'd have to go back to have that addressed or not. Mr. Henderson is also working with attorneys in Minnesota to try and clean up his record, both to make sure that it's accurately reflecting what he was actually convicted of, and also working with some post-conviction attorneys to try and clear his record in a way that's maybe a little more appropriate, reflective of the level of seriousness of the comment that Mr. Henderson has actually.
Okay.
Given that, Your Honor, given that the fact that Mr. Henderson has been in 4 months, that what he really needs to do is to get into some program. We are asking for a sense of time served for clients that additional supervision is appropriate. Mr. Henderson is certainly more than willing to serve a term on probation. We are asking that the court consider time served, given that there is some possibility he will be sent back to Minnesota. The court did sentence him to probation. That's the potential of getting caught.
Okay. Mr. Henderson, is there anything you would like me to know?
Yes, actually, my horoscope on the day that my parole expired, like really, really sharpened my clarity. It says your career could wake up and stretch with new energy, ready for a fresh start to put your energies into the world in a more personally aligned way.
That's a great horoscope.
It is, isn't it? Certificates that I've completed, like I've never had such an opportunity in Minnesota to complete such certification. I completed one called Starters Youth by a man named Brian Hamilton. He teaches entrepreneurship, and for some reason God made me do it twice because it was supposed to quiz me the first time. It didn't quiz me, so I had to do it all over again, and then it quizzed me. So now it's ingrained in my brain. I have worked food service in Minnesota prisons, and they've never given me a certification for food service, so I can open a food truck. I tried to take excavation classes. When I was out in Minnesota, I got kicked out of excavation class because I have a lengthy criminal history. Somebody looked my name up, like, oh, you've been a person, let's look him up. But no, you don't deserve a chance. Like, oh, wow. So I've had a lot of anxiety up there in Minnesota. My horoscope today actually says, discovering your hidden potential, follow a creative impulse and break new ground as Venus and Uranus harmonize. So I feel like it's all like trying to line up for me to get it right. My best friend, he moved down here and then he said, come down here, your hair's gonna grow back. Get better. And my hair is growing back. Like, I'm not thinning anymore. I was thinning really badly. I'm no longer thinning. So, like, I really feel that God has blessed me with the opportunity to do better here in Colorado. So if you do bless me with a release, then I am not going to miss this alignment. I'm going to stay on track because I feel like it's my calling. So.
Thank you so much, Mr. Henderson. Make sure we silence our cell phones. Thank you. Mr. Henderson, I have had the opportunity, one, to hear from you and the parties. I did go back and review, like I do on almost every case, the pretrial bond report. And I think that is certainly the most damning thing for sentencing today is the lengthy criminal history. I don't know if I would categorize it as a streak because it went almost 20 years. And there were only maybe 2 years within that time frame, once in 2014, and I think I saw a stretch in 2019 where you didn't pick up a new case, but almost every year there was a new case between 2008 2006, actually, in 2025, all in Minnesota. So I don't disagree with you. Minnesota is not your place. I'm glad that you're here in Colorado, and I hope that you are able to put some of these new trainings into practice and hopefully can get new employment and get your feet underneath you. Because it does look like most of what you've faced in the past has been thefts. So hopefully you have some more stability in the future going forward. Yes, you can.
Another one that I completed,
Mm-hmm.
inspired by my last court date. This is the cultural conferences.
I saw that.
Because the incidences have inspired me to want to start a program to teach people in the state of Colorado. Also, I wanted to elaborate on Mr. Thomas was explaining. Lucy Chin is an attorney out of Minnesota. Did the pardon paperwork.
Great.
And she said if I'm released here, she's willing to help me with, what's that C word again?
Commutation.
Get a commutation with my active cases out in Minnesota, as well as help me get a pardon of cases.
Thank you for clarifying that. All right. Based off all the information that I've been provided, I do think a county jail sentence is appropriate without any additional probation. I think that you've done a lot of treatment and classes while you've been in custody, and hopefully you can put that stuff into practice. I'm not going to sentence you to 364 days. It sounds like you still have a couple of things to handle with the parole situation and in Minnesota. I am going to sentence you to 180 days, however, in the county jail. For that remaining 60-ish days that you have, work release will be authorized. So hopefully you can get started with maybe some work, working with your counsel that you have in Minnesota. And so it should also cut down on the time on that 60 days. All right?
Okay, how does that work?
They'll talk to you about it in the jail for work release program. Thank you, Mr. Henderson. Good luck to you. You too.
I would just request if we can set the 396 case for a status in about 60 days to
Okay.
that Mr. Henderson has been, that either that release has been, has come through on the extradition case or that he's been extradited.
All right, we will set that in a status time frame in about 60 days. So that puts us roughly at August 17th. We'll set it at an 8:30 status to make sure that Mr. Henderson is not still being held on that matter. And again, for the 180, that has 119 days of credit to be applied with the work release on the remaining time. Okay, thank you.
Just waiting Mr. Henderson's presence for that status date if he is out of custody.
We will waive his presence for that status. I'm also going to waive any remaining fines and costs that I can waive, given that Mr. Henderson has been in custody for quite some time, will remain somewhat in custody, and has some time to get some stability going. Thank you. We need him?
Check.
And just to make sure, Mr. Dawson, can you hear us okay?
Yes.
Okay, good to see you, Mr. Dawson. Give us 1 second.
We can proceed, Your Honor.
Okay. For the defense?
Samantha Looper with the Public Defender's Office. Mr. Dawson appears via WebEx from the jail.
All right. And Mr. Dawson is here on an appearance on arrest warrant. There was a complaint to revoke probation back in 2023 on these cases, but then we had a failure to appear in October of 2024 when he was sentenced to recovery court with Judge McLean. I think it was recovery court.
Yes.
All right. What is the status?
And Judge, during my breakout session with Mr. Dawson, he pointed out the want to resolve the case today with a full-on sentencing. I explained to Mr. Dawson that I cannot proceed today in order to meet my obligations, and that I would need to sit over, calculate his credit, talk to the DA.
Correct.
Mr. Dawson's very adamant that he wants his case closed.
Okay.
I'm not sure. In looking at the case file, it looks like last time he appeared, there was an Arwello advisement. So I'm not too confident on how I can be effective and go to immediate sentencing. I'm not sure if the court wants to inquire of Mr. Dawson, if that's still his needs, and do an advisement. I don't even know if the court can go to sentencing today. I just wanted to put this on the record because Mr. Dawson wants to close out his case.
All right. Mr. Dawson, I just want to check in with you. So previously, you had requested to be able to represent yourself in these matters. You've already been advised of your rights to be able to represent yourself, and there are signed Arguello advisements on your cases. Are you requesting at this time to be able to represent yourself?
Yes, Your Honor. Yes, Your Honor.
And again, previously, I know it's been some time, that Arguello advisement you went through. I remember you were here in person in the courtroom, and that Arguello advisement, you had a physical copy of it. You were advised of possible consequences of your charges at that time. You were provided an offer to recovery court, but you did plead guilty to count one, the class 4 felony, where you did have that sentencing range of 5 to 16 years in the Department of Corrections with the finding of SBI. That's in the 20 CR 1933 case. And then in the 20 CR 2523, similarly, that was also a class 4 felony plea on count 2. Any questions about any of that information you already went through, sir?
Yes, Your Honor. For the last 6 years, I haven't been mobile because
and I don't want you to talk about any possible sentencing argument. I just want to make sure that you understand that if you are asking to be resentenced today, that you understand that your possible options include a Department of Corrections sentence of 5 to 16 years on the second-degree assault, and on the aggravated robbery, 4 to 12 years in the Department of Corrections, given that you've already been sentenced to probation and you've already been sentenced to recovery court in the past, and you're here on a revocation of that.
Yes.
Is that clear, sir?
Yes, Your Honor.
Okay. And let me also just ask you briefly before we discuss anything further. Do you want the opportunity to speak with counsel, or have counsel give the opportunity to speak with the district attorney before you ask to proceed with resentencing?
No, Your Honor. I just I'm at the point now in my life where this is keeping me from
going on with my life, because I had this case over my head for so long. It seems like for the last 6 years I've been incarcerated on this case, months after months after months after time. I couldn't do wellness court. Well, it was hard for me to get to wellness court because of the mobility in my condition. I just want to know how much more time do I have to do to get this resolved, to get this out of my life, to get it done with.
Well,
I haven't caught a
Mr.
new case.
Dawson, before you continue,
Yes.
I can't tell you that before we decide to proceed to sentencing. One, I told you what you're possibly facing of the 4 to 12 years and the 5 to 16 years. So know that is a very realistic possibility that you could be sentenced to the Department of Corrections today within that range if you're requesting to do so. I also know that it sounds like you have some credit on your cases. I have no idea how much credit you have on your cases, which is one of the reasons your attorney was asking to have time to calculate that time, which is still something that even if you decided to go forward with sentencing, we would still need time to do. So before you want to go into this extra explanation, I again want to make sure, do you want to be able to proceed with an attorney or without an attorney? Either way, I'm not going to sentence you right now because I don't have your pre-sentence confinement credit to know how much time to apply if you are stating you would like to be sentenced today.
Oh, okay. Like I say, Your Honor, I just want to get this done with. I take full responsibilities over my actions. And like I say, it's been keeping me from going on with my life because of this case. I haven't taught no new cases. I don't plan on catching no new cases. I just want to get this over and done with as soon as possible, Your Honor.
All right. Thank you so much, Mr. Dawson. All right. Ms. Looper, I'm going to leave you appointed at this time as I'm not definitively hearing that Mr. Dawson does not want to proceed with counsel. I am going to set this matter over. I'm happy to set it over quickly if you would like the 17th at 4:30.
I can accept that time. I guess now the DVDA would have been good to know if there's going to be an offer by the 17th.
Sure. Certainly. We can have Ms. Dessitz, who is the DA on the DV matter, reach out. And if the 17th does not work for anyone in that division, they can let us know. But it sounds like the request is to be able to go forward with resolving that matter. I don't have any information from what occurred really in recovery court. There's no complaint or anything to revoke, just as showing that there was a failure to appear
at sentencing. So he was never sentenced.
At sentencing, and that's all I have.
Okay.
All right. Mr. Dawson, we'll be back. We'll set it for resentencing on the 17th. Mr. Terrell, can someone from your office will be here at 3:30 for sentencing? Can someone from your office be here at the end of that to resolve these matters?
I am pulling up Ms. Dessitz's calendar right now, Your Honor.
Thank you.
I believe she can be here. 3:45, 3:30.
Thank you. Even if she can be here virtually, that'll be June 17th at 4:30 for a resentencing on both of Mr. Dawson's cases. Mr. Dawson, I will see you on Wednesday and hopefully we can get this wrapped up for you then. Thank you. People of the State of Colorado versus Tamel King. Mr. King is here on his case 23 CR 1662.
Roll for people.
In Apoorva Krishnan, on behalf of Mr. King, he appears in person and out of custody.
All right, Mr. King is here for a hearing on revocation. What is the status?
Your Honor, we would be asking to admit to the technical violations today and proceed to sentencing open to the court. The misdemeanor matter is still pending here in Arapahoe County. There is currently an offer out on that matter. However, I did just want to note it wasn't actually filed after the revocation was filed. I think it just was not included in the first complaint. Mr. King and I have been aware of that matter for some time, and he is currently represented by our office on that matter.
Okay, thank you. Mr. King, I hear your attorney saying that you want to admit violating this to the technical violations. So I want to talk to you about your rights and what that means. You do have the right to deny violating the conditions of your probation, even if it's just the technical violations. If you deny violating the conditions of probation, we would set you for a hearing. At that hearing, which is today, you would be permitted to testify, or you could decline to testify. You'd be represented by your attorney. You could present witnesses and confront the witnesses presented by the prosecution. You are stating today that you understand your rights to go forward with a hearing, but you do not wish to do that. You want to admit to the technical violations. And I'm sorry, Ms. Christian, what was the stipulated agreement? Or was there a stipulated agreement?
There is not. No, we would ask to proceed to sentencing open to the court.
And you want to proceed to immediate sentencing today, open to the court. Is that correct?
Yes.
Is anyone forcing you or coercing you to do this today?
No.
Are you satisfied with the advice of counsel?
Yes.
Do you feel like you understand your possible consequences, sir?
Yes.
Are you under the influence of anything today affecting your ability to understand?
No.
Have you ever served in the military?
No.
To the technical violations included in your probation complaints, do you admit or deny violating probation?
I admit.
I will accept your admission as freely made, voluntarily made, and knowingly made. For resentencing, is this immediate resentencing?
Yes, please.
For the people.
Your Honor, on the 29th of April of 2024, the defendant was sentenced with 3 years DOC suspended on count 4. You're here for the second probation revocation. We were revoked and reinstated for an additional 4 years on July 14th of 2025. This revocation was filed just 5 months later. I'm sure the court is familiar with the complaint, sees the counts there, the 10 failures to appear for UAs, the 4 failures to appear for probation office visits, the new law violation pending in 26 M1486. That's a M1 harassment, strike, shove, kick. The defendant also has pending probation revocation in Adams County for an F5 menacing and an M1 assault. Mr. King, dating back to 2013 in his juvenile history, has a lengthy violent criminal history. He has a juvenile F4 robbery conviction in 13 JD 401, which is pled down from an aggravated robbery. He has a juvenile F4 robbery conviction out of Denver case 14 JD 193, which is pled down from an aggravated robbery. Both weapons offenses. He's got an M1 assault juvenile at a Denver 14 JD 386. He's got an M1 assault juvenile at a 15 JD 113 out of Arapahoe County. An M1 assault as an adult in Denver 22 CR 1206. There's a consistent and lengthy pattern of Mr. King using weapons to intimidate other people. That behavior is not stopped. He's picked up another violent offense here in Arapahoe County, 26 M 1486. Again, that M1 harassment, strike, shove, kick. All the while since the sentencing in this case, the specter of the 3 years DOC has been hanging over him, and that has not changed his behavior.
Or
Mr.
the
King
5 years?
Pardon me.
The 5 years DOC?
Yes.
Okay, go ahead.
That has not changed his behavior. There's already been one revoke and reinstate in this case. Mr. King has not been incarcerated, to my understanding, for any real lengthy period of time. Community-based sentencing, probation have not worked. Mr. King is still committing violent offenses, has a lengthy history of using weapons to intimidate other people. And therefore, we would ask for the suspended Department of Corrections to be imposed in this case.
Oh, and you're right. It's 3 years. It was a cap of 5, but 3 years suspended. Okay. And had you advised your client of the suspended 3-year sentence?
Yes, he's aware of that.
Okay.
And to begin with, I did want to cite specifically to People v. Prost 486 Pacific 3rd 456, which does state that the court does not have to impose suspended sentences on revocation matters, and we would be asking that the court consider that as well in determining resentencing today. Mr. King, just to clarify the record, has a total of 374 days of credit on this case. That is a considerable period of time, having been in custody on it. The specific dates of those range from July 2023 to April 2024. After that, he was in custody for a month from June to July of last year, and then February through April of this year. And on my calculation, that's 374 days, which I had sent previously to the people as well. Mr. King has been doing extremely well for himself since he has been out of custody. This most recent time, he's currently doing IOP. He started that a few weeks ago at Hazelbrook. From what I heard from Josh Romero, who is his current house manager, he's been opening up a lot to both Mr. Romero as well as his peers during his classes. He's taking life skill courses, as well as meeting with a one-on-one therapist every week. I did ask them specifically about UAs, as well as any other programming that he's doing. And in addition to his IOP, he has had clean UAs, and they have currently no concerns about Mr. King's participation in their program. Mr. Romero spoke very, very highly of Mr. King. They would love to have him continue there. And I believe once he's done with his 90-day program, which he has about 2 months left on, he is going to continue there on in sober living, after which point they'd be able to assist him in his job search as well. He's not currently working due to the demands of the courses that he's taking, as well as the therapy. It is quite intensive during that initial 90-day program that they have. Mr. Romero was very impressed, frankly, with Mr. King's progress. He did note in particular that he would like for Mr. King to stay on as a house manager when he gets to that point in his recovery. And Mr. King has been working very diligently with me to try to get this case handled. He's been very dedicated to his treatment. And that is something that he, I think, is taking very, very seriously here, despite his financial constraints while he was on probation. I did just want to note as well, understanding that there was a suspended sentence. With Mr. King's credit, functionally, I think what that suspended sentence would do is remand him, make him almost immediately parole eligible, and basically just turn him out again on parole. What it would also do is interrupt the treatment that Mr. King is currently receiving at Hazelbrook. So despite the number of days he has, which is a little over a year, we would be asking for a 90-90 to close this out. I do think that that takes into consideration the time in custody that he has already spent, but also I think logistically would allow him to continue on with treatment in a way that a DOC sentence, even up to that 3 years, would not. Frankly, even if we were to do a year of DOC with credit for time served, he would still have to be remanded, interrupt his treatment, and then basically be turned back out again. So based on that, we would be asking for a 90-90. Mr. King did also just want me to share, I think the court is very familiar as well with some of the support systems that he has in his life from when he was sentenced on this underlying case. It has been some time since then. Mr. King's daughter, Majesty, is now 11 years old. He's still very present in her life. He's really hoping to move forward from these cases and continue on with treatment. She is his primary motivation for doing that. His family members, including primarily his mother and his sisters who do help with childcare for Majesty, are transitioning between some of their work requirements and scheduling has recently been quite challenging for them for childcare. Mr. King really wants to make sure that he is able to contribute to her childcare, that he's able to be there for them, and able to start working as well to continue supporting her. Truly everything that he's been doing out of custody has been in service of A, getting through treatment at Hazelbrook, and B, making sure that she has her needs met, including new clothes, making sure that she's getting to everywhere she needs to go, making sure that she has him as a positive role model in her life too. Just briefly on the misdemeanor case, That case, understanding it's a summons case, I did just want to provide the court a little bit of context. Mr. King is still pre-conviction on that case, is presumed innocent of those allegations. It did ultimately arise from a jail fight while he was incarcerated here. There's not a whole lot of information in the minute order there, but I did just want to note that as something that was relatively different circumstances from what we are facing in this case here today. He has received some separate offers in that case. They would likely be affected by how this case gets sentenced as well. I know they were trailing us for now. That said, I do think that a 90-90 here would allow him to move forward from this case, just given its age, given the amount of time that he's already served on it. And I am in communication with the misdemeanor attorney as well to see if there are any other options for him through that misdemeanor case. While I do think that he's getting as much treatment as he needs and could possibly receive currently at Hazelbrook, I do think that they are considering some other resolutions as well in the misdemeanor that may contribute to that as well.
When is he next set in the misdemeanor case?
I believe they're set on the 23rd.
Yeah, I think I saw it was sometime later this
Yes.
Okay. And then for that pending revocation out of Adams, is that right?
It should be Adams County.
Do we know, are they potentially resolving in a similar manner with a 90-90 or a Department of Corrections sentence?
They were also currently continuing to trail our court date, so I do think that will inform that quite a bit. However, for their charge, it is the same level of charge for us. I believe it was the same
F5?
Yes, it was a F5 menacing. I believe it was the same suspended
sentence.
3 years, yes, or at least that would be his exposure regardless.
All right. Mr. King, is there anything you would like me to know at this time?
Yeah, I just it's been a little ride. Back in 2021, I believe my sister passed, and I lost my apartment and everything. And I went through what I went through, and I had a little bit of trouble on the streets. Ever since then, it's like I just been trying to get back on my feet. Probation, I felt like I always did good in probation, but the thing was that I just sometimes didn't have a place to stay.
Yeah.
And, it got hard to report to probation because, I didn't have my, personal things together, and I lost my car and everything. But honestly, ever since I've been in Hazelbrook, they've been actually showing me a way to get back on my feet, helping me out. The IOP program is pretty good. And, I'm meeting new people and I'm learning new things. I just think that I think I'm ready for a different change in my life now. And I've had some things in my past, my juvenile and stuff like that. And I want to apologize to the courts for those things because I understand that that I was young, and I understand that that I was going through a lot of things. And now I'm just realizing that it's more important to always stay on what I need to stay on for my daughter. And that's what I'm working on towards now, because my family, they are support, but I am her father. So I feel like I need to be there more, and I need to work harder to be a father. So the Hazelbrook has really been helping me with that, and I got a lot of support there. And I'm just ready to get back on my feet the right way for my child.
All right. And just to clarify, because I do hear that he has some good progress with Hazelbrook, will they continue to hold his space after any sentence that he may have, like if he has a 90-90?
I have not confirmed that with them. I know that with his credit, he has over 90, but I'm not sure if they would hold that after.
And I don't know if I know that he has credit. You're requesting that I apply credit to his 90-90?
Yes, please.
Okay. All right. Mr. King, thank you so much for your comments today. I do just want to state that you have always been respectful here. You have always been timely. And I can tell that you have been working very hard recently to get back in compliance. I do certainly have to take into consideration that this is the second revocation on probation. So that's certainly nothing to minimize, and also recognizing that it's a second chance with a suspended Department of Corrections sentence, and the prosecution is asking for that DOC sentence. I do appreciate you requesting to take accountability today, knowing that you have Hazelbrook on the line, you have your daughter that it sounds like you want to get to as well. But I am going to accept the proposed agreement that you have, recognizing that on a 90-90, I do not have to impose the time that you have, but I can impose some of it, which is what I'm going to do. I am going to sentence you to 90 days of probation with 90 days in the county jail. As a part of that, I am going to apply 60 of your days to that sentence so that you only have a remaining 30 days. I'm doing that because that is a large deviation from you're looking at 3 years suspended DOC, and that's not what I'm imposing, but I am going to impose some punitive sanction because I do think it is necessary that people understand that when we give you another chance on probation, that's not something that you get in a lot of other divisions, and I hope that people take it seriously. So that will be 90 days in the county jail, 90 days of probation as a condition with 60 days applied to that sentence, so you have 30 days left on that sentence, okay? So we remanded at this time, and then you just have that 30 days left. Okay, thank you. Do you want me to
Okay, so the case isn't a VRA case, so we can go ahead and call it just a few minutes early. Court will call People versus Robert Geese, 26T884. If you'll come on up and have a seat at the table. And then I show we have Ms. Morissette and Ms. Shireman for the People. All right, so I show that we're set on for a motions hearing. I don't show that there were any motions. I believe the motions that were previously filed had to do with obtaining discovery. Is that correct, Mr. Geese?
Yes,
Okay, and how do I say your last name?
it is Geese.
Geese,
As
okay.
in Canada, excuse me, Canada Geese.
Okay. All right. So I have not received any endorsement of witnesses or defenses for your case. So I take that to mean that you won't be calling any witnesses other than possibly testifying yourself. Is that correct?
Your Honor, thank you, first of all. Good afternoon. I filed the motion for discovery, and there are 6 points, actually 7, but 6 points within that motion that have not been answered. And I also filed an affidavit of truth, and that has not been answered. Therefore, I don't understand how the court can move forward. I do want to correct the record on a couple things, if I may. Do I have your permission to read this into the record?
So let's go back to the question that I asked first. Are you going to be calling any witnesses? Because you did not file any endorsement of witnesses.
I don't know how we can move forward calling any witnesses without answering the motion and affidavit that's before the court presently.
Okay, why don't we start then with your motion for discovery? What exactly is it that you're claiming with the motion for discovery?
Do I have standing to read this into the record, first of all?
You don't have to ask for standing, so.
Thank you. Respectfully, for and on the record, I am Robert Geese, a living man of the Union, a non-belligerent or enemy of the state, and I occupy the office of executor and co-trustee for the Nole Me Concari Express Trust. I am here propria persona in that regard, not pro se, by special appearance only, not generally. Further, I'm of the age of majority by both the age.
Can I stop you for just a second? I am not going to consider claims that you're saying that I can't proceed on the case because you are not a citizen or anything like that. We're not going to proceed that way, okay? So did you say that you had some actual discovery issues that you needed to address?
Your Honor, respectfully, am I being denied my due process rights of being able to read this into the record?
You can file whatever you'd like, but no, I'm not going to sit here and listen to you just read a document into the record. Okay?
I object.
Okay, that's fine. So did you have any actual discovery issues for us to address?
The discovery I filed, it's in writing. I don't know that it's necessary to sit here and read everything into the record. You just said that you don't want me reading into it, and now you're contradicting that with something else.
Have any actual discovery issues? Is there some part of discovery that you believe that you have not received?
All of it. Nothing's been answered.
Okay, so this is not a situation where they have to answer questions, okay? This is not a civil case where you get to do depositions or ask interrogatories. As part of a criminal discovery, they're required to give you some documents through the case. Did you receive the discovery?
Did I receive what discovery?
Okay, have the people provided discovery to the defendant? I don't think so.
Sorry, double checking through the workflow, Your Honor. Yes, it has been provided.
Okay.
What did that consist of?
Can you let me know what discovery you provided?
So that would be all the evidence from the case. So that would be reports, just like criminal history. Looks like there is body worn camera available. Basically anything in our case file that's evidentiary would be provided to you. Typically you have to go to the front desk of the DA's office and pick it up because there are large files, so they'll burn it on a CD for you. So if you haven't picked it up already, it's probably sitting behind our front desk ready for you.
Have you picked up that documentation yet?
I've never been given any notice of anything, and
So
the question I have is this so from
discussions about how to obtain discovery from the district attorney's office?
I object. I don't understand how this court can move forward. I have been very succinct with my motion for discovery.
So
if I understand what you're saying, pardon me, may I continue? Yes?
The way that discovery works is that you are required to go pick it up from the DA's office, okay? So it is not a situation where the court is determining whether the case can proceed. This is not a felony matter where the court is having a preliminary hearing or anything like that. So you have not filed any motions other than the fact that you did not receive discovery. So you know the procedure to get the discovery. You need to go to the DA's office to obtain that.
I'm referring to my motion for discovery, my requests, demands, really. And if I may go back to something you mentioned earlier, Your Honor, respectfully again, if I could have finished what I wanted to read into the record, I come here in peace. But you mentioned that this is not civil, this is criminal. Is that correct?
That is correct.
So there's a crime committed here.
So I'm not going to have these discussions with you, okay? If you want to file a specific motion to have me rule on it, I'm happy to do so. This is not a situation, like I've said several times, where the court is making a determination about a preliminary hearing or anything like that. So you have not filed any motions other than not receiving discovery. I am not going to say that there's no jurisdiction to move forward or anything like that. That is not the situation here. Okay. So at this point, you need to go get the discovery from the district attorney's office. I told you that when we set this for trial. If you decide not to do that and don't have that information, that's up to you. Okay. So at this point, I'm not going to grant any of your motions because there hasn't been anything that has anything that would have anything to do with a motions hearing at this point. The court is going to deny those requests. We are set for trial readiness on July 14th at 11 o'clock. And then we're set for jury trial on July 29th at 8 o'clock. Trial readiness is the last date that the court will accept any plea agreements. Because you have not filed any endorsement of witnesses or defenses, then you will not be permitted to call any witnesses at trial other than possibly you testifying yourself. You also would not be able to assert any affirmative defenses, but this does not appear to be the kind of case that any affirmative defenses would apply.
I object. I do not consent to this procedure.
You don't have to consent. So
Absolutely.
I am.
And I object also the fact that I'm being denied my due process rights to read into the record, regardless of what this is.
You can
procedure is
file
called.
whatever you'd like, but I'm not going to sit here and waste court time with you reading things into the record. You can certainly file whatever you'd like. Okay.
I have done that, Your Honor,
I have.
and they have not been answered.
We are not required to answer essentially interrogatories from you. That is not required. So I have denied all of your motions. So we will continue the case then to trial readiness on July 14th at 11 o'clock.
So if I may, Your Honor, you are denying that this court or prosecution has any need or any responsibility to answer my motion for discovery, my affidavit of truth, which are all in writing.
There is no grounds for you to file any affidavit of truth. There is no right to a preliminary hearing or anything like that in county court. So it is not a situation where the court is going to make a determination ahead of time regarding any of the facts. That would be what the jury trial is for.
In my motion, I reserve my right to a trial by jury of my peers.
It's set for a jury trial.
I don't want a jury trial. Why would I want a jury trial? I want a trial by jury of my peers.
It doesn't mean it's your friends and neighbors. It means it is a jury panel in Weld County.
Isn't that what it's supposed to mean?
I am not going to fight with you about this. Okay.
I don't mean to
So
fight.
the case is set for a jury
Posing
trial.
questions.
Okay, so it's time for you to go. I am not going to sit here and fight with you about any of this. All right, the case is set for a jury trial.
Thank you, Your Honor.
Thank you.